Okay, cool. Let's kick off. Well, thank you everyone for coming along to our webinar today on privacy essentials for small businesses. I'm Alex. I'm the co-founder of Sprintlaw. For those that don't know too much about us, a quick word on who we are. We're an online law firm really designed for startups and small businesses. Unlike your traditional lawyers that charge you large amounts of fees per hour, our model is a little bit different. We provide fixed fee legal services, which means most of what we do will give you a sort of upfront quote, which is the price that you'll pay for our services. And we cover pretty much all areas of commercial law, from privacy, which we'll be talking about today, all the way through to contracts, financing, employment law, business setup, and those sorts of things. We also have an optional membership. The majority of our clients sign up to it. It's a really great way to build an ongoing relationship with us as your sort of longer term lawyers. As a member, it's a pretty low annual fee, and you get access to unlimited quick calls with our lawyers whenever you have a quick legal question, a discount on any services, and a few other sort of software tools that we have. We are a team of a bit over 50, have been around for about 6, coming up to 7 years now, 6,000 clients, lots of happy customers. We've won lots of industry awards, and we're based in Australia, but also have operations in the UK and New Zealand as well, for those of you that are running international businesses. So let's move into the content for today. Privacy essentials. We'll be running through a few different areas of privacy law. First, we'll just begin with just talking about why should you actually care about privacy? Why does it matter to your business? What's the importance of it? And why is it a thing that you should think about learning about and potentially investing in? We'll then go into your actual legal obligations. What are your legal obligations around privacy? What do you have to do if there's a breach of privacy? We'll then talk about protections. What steps can you take from a legal perspective to ensure compliance and reduce some of these risks? And finally, we'll touch on some of the recent changes in law in Australia, and also very briefly just touch on some pretty big changes that are being discussed for next year in Australia as well, which will affect a lot of smaller businesses. As I'm going through, if people have questions, we have a chat and a Q&A feature. You will have hopefully a little bit of time for questions at the end, but I do prefer to answer questions along the way while we're on the topic. So, I'll try and answer as many as I can. So don't be afraid to drop a question in the Q&A box. So, beginning at the top, why should you actually care about privacy and data protection? Well, there's a few reasons. The first one is that threats are increasing. Cybersecurity incidents, just in Australia alone, are estimated to cost the economy about $29 billion annually. We have seen in the last 3 or 4 years significant increase in ransomware attacks and other attacks against individuals and businesses' personal information. So it's an area which is likely to affect more and more businesses in the future, and hence the need for an understanding of how this whole space works and taking steps to protect yourself, I think, is becoming more and more important and is only likely to increase in the future. The second is, and it's kind of a related point, because we're hearing more about data breaches, about privacy in the news, we're hearing about incidents of cyber attacks, we're seeing customers care more. It's a much more common question that your customers may ask you, whether now or in the future. What are you doing with the information I give you? How do you handle it? What policies and procedures do you have in place? And if you don't have well-prepared answers to those questions, it may actually affect your customers' trust in your business. So it is a thing that's not just about theoretical risk, but actually is a important part of the day-to-day operations of your business. The third is increasing enforcement. So, Australia's had privacy regimes in place for decades, but the Australian privacy regulator, the OAIC, has been referred to in the past as a toothless tiger, in the sense that they have a lot of powers to find businesses, but they rarely go out and actually do anything about it. And there's privacy breaches happening, it's been said, all around Australia that are left undetected. That reputation is changing. We are seeing more enforcement by the regulator, actually taking action against businesses. As we'll come to later, they've been given, since late last year, more power to actually make enforcement actions and gather data from other sources. So again, the future may not resemble the past. Even if you've been in business for several years and you've never really had issues with privacy, that doesn't mean you won't in the future. And I guess the final point is that the laws are actually changing. And again, I just mentioned there was a change late last year to the Privacy Act in Australia around enforcement and information sharing. There's changes being discussed, really targeting small businesses and removing exemptions for small businesses around privacy law. That's being discussed for next year. The GDPR, people may have heard of, is a European/UK law that came out a couple of years ago and has really changed the landscape and the way people are now thinking about privacy. And other acts, not just the Privacy Act, but other laws are changing around privacy. Again, putting more burdens on businesses that didn't exist in the past to care about this stuff. So many reasons to care. I just also wanted to give a couple of case studies people would have seen in the news. We had two big high-profile Australian data breaches occur last year. One was the Optus data breach, and one was the Medibank data breach. Interesting as a case study to look at like what actually happened, and also just reflect on, obviously these are large businesses, but the impact that these breaches had on the businesses as a little bit of a case study as to where things can kind of go wrong. So for Optus, last year, they were the victim of a cyber attack, which resulted in the disclosure of a lot of their customers' personal information, things like names, dates of birth, driver's license, Medicare card, and passport details. Now, Optus hasn't really got to the bottom of exactly what happened, but the rumor is that it's the result of some form of human error that occurred, which enabled the attackers to breach their system, get in, and hold this information ransom before ultimately publishing it. And Medibank, similar, they were subject to an attack in 2022. The data got leaked on the dark web with information of customers' names, numbers, policy numbers, and some claims data after Medibank didn't pay a ransom payment that was requested. And so, again, it looks like it's the result of human error. And, people often say you can pay all this money, to protect your systems from, potential cyber attacks. But, ultimately, oftentimes it's the human element of the system that can cause the problem. And certainly that appears to be the case with both of these businesses. And it was obviously significant to both of their reputations. Large amounts of money were lost. You may have received some notifications from them if you're a customer of either of them, which gives you a sense on the receiving end of what it feels like to be a customer in a data breach scenario and what their legal obligations are. They suffered serious financial losses, but also had insurance policies and things step in that help protect them from some of the side effects of the damage to their business. So with those in mind, we can start to reflect on what the costs are of a data breach. Reputational damage is a big one. That was suffered by these two case studies. It will be suffered by your business. You don't want to be in a situation where you're required by law to tell all your customers that their information has been lost. And you may well be, if that happens when you're holding their personal information, as we'll come to in a moment. It's not good for your reputation. It reduces customers' trust. In the future, if you're asked, have you ever had any data breaches, you would have to say yes to that question. So if you can avoid it, avoidance is always the best strategy. So do think about what damage that could really do to your business. The middle category is fines, legal costs. If there is a data breach and you haven't taken appropriate steps to prevent a data breach and you don't have clear privacy documentation in place, you can be fined by the privacy regulators. They can issue a notice to you requiring you to pay them an amount of money, and those fines can be pretty high, potentially business ending, depending on the volume of breaches. And then legal costs dealing with all this stuff. Again, it's easier to put preventative measures in place and procedures. It's less easy to not have those procedures in place, and then after the incident occurs, try and fix everything. It'll cost you a lot more and possibly increase the volume of any potential fines. And finally, increased IT costs. less of a legal point, but certainly if you're not thinking about this stuff early on, the cleanup becomes a lot harder if you don't have things like backups in place when you are suffering one of these ransomware or other sorts of cyber attacks. And finally, just the benefits of compliance. Again, it's not just a box ticking exercise. There are real commercial advantages to investing in privacy for your business. We've got this study run by Cisco where they analyzed a large number of global enterprises and identified that businesses that invested in privacy were getting several benefits beyond just risk management. Improved innovation, improved competitive advantage, more efficient processes because they'd actually gone how to think about where personal information's collected in their business and tidied that up. Obviously, lower losses from data breaches and shorter sales delays with customers and more appealing to potential investors. So you can see a broad range of real tangible benefits to investment in privacy. So we've talked about why this stuff matters, but what are the actual legal obligations that you have as a business in relation to privacy? So there's many different ways to look at it, but I think three broad categories you might want to think about in understanding what your legal obligations are first of all, just general privacy compliance, the kinds of procedures and processes you want to have in place in your day-to-day business activities. So there's a suite of things you have to or should be doing to make sure that every day that you're dealing with personal information, you're complying with the privacy laws. The middle category is the notifiable data breaches. So if an incident does occur, there are a series of processes and procedures you are, in many cases, required by law to comply with. So this is incident-based, but there are incident-based legal obligations to be aware of. And finally, director responsibilities. For any of you here that run a company or are a director of a company, you have obligations that require you to avoid conflicts of interest, not improperly use your position. And there is now talk as well of an additional director responsibility being introduced to maintain your customers' information and keep it under reasonable security measures and keep it free from potential cyber attacks. So it's not just the law that might apply to your business, but you as an individual director may actually have responsibilities to think about privacy and data protection, and maybe in some cases personally liable if you are negligent in the way that you deal with your customers' personal information. So those are kind of the three areas, and we'll go through each of them in a bit more detail in turn. I noticed a question or comment here on a recent AWS security convention. One of the storeholders mentioned that most breaches happen from the 1% that security software don't cover. Yeah, that's an interesting comment, and I think worthwhile in thinking about your cybersecurity practices. So let's start by talking about your obligations and general compliance. The Privacy Act is the main piece of law in Australia that talks about personal information and privacy. And this term I've used already a little bit, and you'll hear a lot in the world of privacy law, is this concept of personal information. And that's information about individuals that could be used to identify them. And so the Act covers any time that you're collecting personal information, you're using it, you're storing it, and you're disclosing it in the federal public sector, or in most people here's case, the private sector. This Act may apply to you and tells you kind of what you have to do with that information. So, most people would have a contact form on their website. Most people will receive emails. Most people would have customer lists. Others may have CRMs or other sorts of things. Somewhere in your business, you probably have customers and you are collecting information about them, their name, their email, and so on. And this is the realm of privacy, which says, now that you have this information, what do you have to do with it, and how do you have to protect it, and what do you have to do in relation to the information and the customers? So currently, the Privacy Act has a kind of 4-point test to work out if it applies to you. Now, I should mention this test is potentially going to change next year and be broader with some proposed law changes. We'll have to see if they go through, but I would expect there to be some changes to these criteria in the coming years. But currently, this is the factors that you use to determine whether this act applies to you. First of all, do you handle personal information? As I kind of mentioned, it's pretty rare for a business not to handle personal information. There are some niche businesses that maybe they don't deal at all with individuals, but the vast majority of businesses will be collecting names, emails, phone numbers, and those sorts of things. So for most, that's a tick. The second is, does your business have an annual turnover of 3 million or less unless they trade in personal information or are a health service provider? So this is a very important limb, and this is what we often colloquially call the small business exemption to the Privacy Act. So if your business is making less than 3 million, you actually, in many cases, do not need to, by law, comply with the Privacy Act, which is the main piece of privacy legislation in Australia. Now, that might sound good. You might think, well, that's me, and can I quit this webinar now? The answer is I wouldn't advise you to think that way. There's a few caveats to this second bullet. So let me just run through them. First of all, this does not apply if your business trades in personal information or is what's called a health service provider under the Privacy Act. So, and there's a few other similar exemptions for people like accountants who might collect things like TFNs and so on, which is also kind of covered in this third bullet point. But if you are collecting health information about people's medical history, conditions, other sorts of things, it doesn't matter if you're under 3 million, you have to comply with the Privacy Act. The second is, if you're a business that trades in personal information, which is a fairly broadly defined phrase in the Privacy Act. If you are in some way in your business taking personal information and monetizing it, maybe you're sharing it with partners for email offers, maybe you're sharing it with other parties, selling lists in some way. If you actually turn that contact information or personal information you have into money in some way, in and of itself, doesn't matter if you're under 3 million, you have to comply with the Privacy Act. And finally, even if you are under 3 million, if you think your business in the future will grow beyond that 3 million turnover, it can cause a lot of problems if you're not complying with the privacy practices from day one, because not only will you have to begin complying past that point with future customers, you may have to go back and seek consents from your early days customers from when you were under 3 million. So it can create a lot of problems when you tip over that point. And we generally advise all businesses to just comply anyway, even if they may be able to rely on one of these exemptions. A further point again on this is this I'm expecting to potentially be abolished next year, and the small business exemption will be removed. So again, not a bad time to start complying now. And GDPR, for those of you that operate in the UK and Europe, doesn't have this exemption. So if you're selling to customers overseas, you're going to need to comply anyway. It's quite unusual that Australia has this exemption, and it is somewhat a legacy piece of law from a bit over a decade ago. The third category where you can fall under the Privacy Act is if your business handles special categories of personal information. So these are things like tax file numbers, government-related identifiers, credit card numbers, or other what's called sensitive information, which is defined in the Act as information that's like passport information or highly sensitive information that people wouldn't want disclosed. If you handle any of that information, doesn't matter what your revenue is, you need to comply with the Privacy Act. And there's in fact additional requirements around those specific types of information. And finally, we have the bottom criteria, which I've already touched on, where there are certain acts or practices that are specifically exempt from the Privacy Act, which may be governed by other laws. So this gives you a little bit of a sense of whether it applies to your small business. In short, it applies to a lot of small businesses that tick the box of collecting some form of special personal information. If you don't do anything like that and you're just a small business under 3 million, actually the compliance is optional, but for the reasons I mentioned, we still recommend complying for that day where you may go over that mark, or for potentially in the future when this is abolished and will create a whole bunch of challenges for you. Um, I have noticed a few questions in the Q&A, so I'll just have a quick look at them. Do we need a privacy policy on our website? If we're starting out, we collect emails for the initial signups. I'm going to touch on that in a couple of slides' time, but in short, the answer is we would recommend you have one, yes, and we recommend anyone does that's collecting information for signups. Whether you need one or not, again, depends on whether you're above or below 3 mil. If above, then you need one. If below, it's good practice, but not currently required. Again, assuming that you're only active in Australia, but for the reasons I mentioned, we would recommend it. Another question, what if the selling is happening by users of your platform and you only provide them with platform services while you store their identity information, not financial or other info? The fact that you have their identity information collected and stored somewhere in your system means you are storing personal information. Again, it's as simple as you're collecting name, contact number, phone numbers. We're now in the realm of privacy law. If they're stored in systems controlled by you, then we're in the realm of privacy law. Same answer, whether you have to comply or not, depends on where you sit in relation to the tests that I just ran through. But we would always suggest that, again, privacy policies and other sorts of privacy compliance are things that you look to put in place. And a question from Justin, I'm a piano teacher, less than 3 mil per annum. I specialize in teaching people who are neurodivergent. I collect professional diagnoses of students. Does this mean I'm not exempt? To give you a specific answer, probably need to ask more questions about your business. I can probably only now on this public webinar talk in general terms, but I will say when businesses are collecting things like diagnoses, it strongly suggests that that's health information and you may be considered a health service provider. And the requirements for that are quite broad as well. So I would encourage you to chat to our team to confirm whether or not it applies. We probably need a bit more info, but there would be a suggestion that in this scenario, yes, you would be considered a health provider, in which case the fact that you'd be less than 3 million doesn't specifically, you can't rely on that exemption. So assuming that the Privacy Act applies to you, what are the main things you need to do? Well, the first thing you really want to be doing is putting in place key privacy documents. So these are documents that I'll run through in a moment, but things like privacy policies, privacy collection notices, and other sorts of manuals and procedures. Some of these are required by law. Some of these are recommended for compliance. So you really want to make sure that you've got the documentation in place and you're complying with the processes that you're saying you're complying with in that documentation. So that's step one, get the documents. Number two is think about the notifiable data breach procedures. What processes and procedures are you going to put in place if something happens? Are you ready to go if tomorrow there's a cyber attack? Do you know what you're going to do? Are you ready to notify customers, notify the regulator? And we'll come to some of this stuff in a moment. Be aware of what the processes and procedures are. The third and fourth I've touched on already, but be aware of what's happening in relation to enforcement and be aware of the changes in laws and how they may affect your business. You don't want to be set up with outdated privacy documents where the laws have changed. You thought that you were taking all the steps that you needed to, only to find out that you need to update your documents. There's things you need to do now, and you're potentially going to be fined under these new enforcement measures. So think of it as something that's not just a one and done for your business. I've set up my documents, I've set up my breach procedures, but actually this is a moving and fluid space that I need to be across what's happening. And I would encourage most businesses at least once a year to have their privacy documents and maybe if you can afford it, your legal documents more generally reviewed and checked for compliance with current laws. But certainly if you don't want to check all your legal documents, privacy is one area where things are changing. And so it is a good idea to get them checked every so often. So let's dive into the Privacy Act and what it is that you actually have to comply with. Well, the Privacy Act uses what we call a principle-based approach to privacy regulation. So it will be very nice if the Privacy Act said, okay, Privacy Act applies to your business. Here are the 5 things you need to do, and it's all good. You've ticked the box. That would be nice. Then we'd all here know we only need to do these 5 things and we're complying with the act. Unfortunately, it doesn't work that way. It's a lot more wishy-washy, and it uses these principles. So what it essentially says, to kind of paraphrase a very long and complex document, is if you're a business to whom the Privacy Act applies, you must treat customers or others' personal information in accordance with these 13 principles. You must be open and transparent about it. You must use an anonymity where you can. You must collect it in a certain way. You must notify them of how you're using it. If you're doing direct marketing, you must think about these things. If you're disclosing them overseas, you must think about these things. There's 13 principles in there that you need to comply with in the way that you handle people's personal information. So it does provide a bit more info on what that means. But ultimately, as you can see, and I won't go through everyone in detail, but you can see that there is a sense here of treating people's personal information with a certain level of care. And that's the essence of what the Privacy Act says. If this applies to you and you're collecting this information, here is the principles that you must follow when you're handling their personal information. So to make that a little more tangible, lawyers have interpreted these principles, and we've come up with a suggested suite of documents that we recommend businesses put in place. And this is to show evidence that you are complying with the core principles. Now, some of the principles are quite specific when you read them. For example, APP1, which says you must be open and transparent about the way you manage personal information. If you read it, it literally says the words, you must have a clearly expressed and up-to-date privacy policy explaining how you manage personal information. So there's not much question about that. If you want to comply with number 1, you need a privacy policy. So to answer the questions earlier, again, anyone falling under the Privacy Act, it's mandatory to have a privacy policy. APP5, which is you got to notify people when you collect personal information. Again, the principle is pretty specific, not as specific about the exact document, but it says when you collect information, you must take reasonable steps to notify the individual to ensure they're aware of those matters. So lawyers will call this a privacy collection notice that we recommend you have. It's mandatory to have a collection notice. For those of you out there going, what the heck is a collection notice? I've only ever seen a privacy policy. A collection notice is not necessarily a standalone document. It's a phrase or a sentence that you will use to point back to your privacy policy. So for most people who are probably thinking of putting a privacy policy on their website, the collection notice is at the bottom of every contact form, that little sentence that says, we are collecting your information in accordance with our privacy policy, and they'll link back to the privacy policy. So it's not good enough to just have a privacy policy sitting somewhere that nobody knows about. You every time collect people's personal information, you want to inform them of the privacy policy and make it easy for them to actually read it. And that's what the collection notice is about. Now, digitally, it's usually a sentence with a hyperlink. But for those of you that might collect information offline, if you've got physical sign-up forms, paper-based sign-up forms, you may then want to put on page 2 of your sign-up form, maybe a shortened version of your privacy policy and a little collection notice there, or at least a collection notice, and give your making it easy for your customers that are providing you that information to go access your privacy policy somewhere. So ultimately, the policy is going to say what you're doing with the information, how you're using it, and then the collection notice is going to draw people's attention to that privacy policy. So for those that don't have these things, these are the top 2. Get a privacy policy and then insert references to it where you can around your business. That's a really, really key action to focus on for compliance. Now, there's a range of other documents. They're not mandatory, but if you want to show that you're complying with all of the other principles in the Privacy Act, we recommend considering having these forms of documents in place. The APP6, for example, says you can only use or disclose information for the purpose for which it was collected. So having a privacy impact assessment where you actually look at your business and you say, okay, well, where are we storing people's personal information in the business? Obviously, I get emails, so I got their name and contact details in the emails. But where is the information going afterwards? Is it in 50 different places in my business? Is it in spreadsheets? Is it in printouts? Is it saved down into folders? Is it in CRM systems? Where is all the information? And am I making sure that those places are actually secure? Or what am I using to kind of clear out information from places that it's not needed. One thing we do at Sprintlaw, for example, is we're collecting customers' personal information on various sources and various areas of our site, but quite regularly we'll go through and clear out information or only store it temporarily in certain areas of our system to make sure that the points of failure are lower. So this impact assessment is a good thing to do to make sure that if you've got permission to use the information in a certain way, you don't have it in too many spots and it's not being inadvertently used for purposes it was not authorized to be used for in your privacy policy. For those that do direct marketing, so that's when you're sort of doing telesales or door-to-door sales, there's quite specific provisions in the Privacy Act about what you need to do, and we recommend an additional direct marketing policy, which involves how you disclose the way you're using people's personal information. For those of you, which with most businesses who are collecting personal information and then sharing it with some kind of vendor, whether it's a software provider or subcontractor, somebody overseas will have access to your customers' personal information. You have a requirement under the Privacy Act to take reasonable steps to make sure that they don't breach the APPs when you share people's personal information with them. So if you collect your client's info and then you've promised to treat it in a certain way, only use it for certain purposes in your privacy policy, but you share it with a third party and they use it in some other way that is different to what you collected it for, and the end customer suffers loss as a result, if you haven't taken reasonable steps to have some oversight over what your subcontractors and vendors are doing, you can potentially be liable for breaching the Privacy Act. So we recommend having a privacy clause in your agreements with your vendors and suppliers. Something in there that says, under the terms of our arrangement, I will be sharing personal information with you of my customers. Our privacy policy is here, and we've promised all these things to our customers. You must treat our customers' personal information with the same level of care. And you may put some procedures in place to make sure that they're not just nodding their head and signing, but are actually treating the customer's information with care. And provided you can show evidence of that, there's a good chance you could be shown to be complying with APP number 8. Data breach response plan. This is APP 11. If you are subject to a data breach, someone hacks your system and takes your customers' information, their names, their email addresses, or anything else, you have obligations to take reasonable steps to protect it. So having a data breach response plan in place, which is a semi-legal, semi-IT document that sets out what you're going to do if there's an incident, how you're going to shut down systems, restore from backups, notify customers, et cetera, so you can move quickly if something occurs. It's a good idea to have that in place to show that you're taking those reasonable steps to protect people's personal information from misuse. There's other things you can do: cyber insurance, invest in IT security. These are not really legal things, but again, that gives you a sense of what you need to do for APP 11. And APP 12, you've got obligations to give the individual access to their personal information. If they say to you, "What are you doing with my personal information?" There's, with some exemptions, requirements for you to respond to those requests. So again, you may want to have a procedure in place for how you provide it, what format you provide it in, and how you deal with any complaints that you get to show that you're complying with handling guidelines. So just to address some of the questions raised, one question, APP 5 can be included in the privacy policy. If you're talking about, APP 11, okay, so the data breach response plan. So the data breach response plan is actually an internal document. So it's not something you notify to customers. It's more of an internal procedure that you put in place so that your team knows how to respond to a data breach. So certainly you'll tell your customers, we will take reasonable steps to protect your information from misuse in your privacy policy. But what we're suggesting with the data breach response plan is another document internal which says, okay, team, if something happens, here are the 10 things that we're going to do. We're going to immediately tell customers there's an incident. We're going to shut down our systems. We're going to do this. We're going to do that, etc. That's what a data breach response plan is. So it's an internal policy document. You don't share it with your customers. But again, if you want to be showing the regulator or anyone else in the future that you are a very compliant organization, you would say, not only do we have a privacy policy, we also have this internal data breach response plan. So that's why we recommend putting it in place if you can. Phil's asked, if I'm providing infrastructure to a customer who collects people's information, I don't get the opportunity to tell the person whose information is being stored that I'm doing that. Does the responsibility then devolve to my customer? That's a very interesting question, and again, probably one where you want to get some specific legal advice, because there's many different ways to handle that situation. But take, for example, we're all on Zoom right now. And so Zoom, in a sense, is providing infrastructure to Sprintlaw, who is then, you guys are all on this webinar call, and where we have your names in some cases. So we are collecting personal information. We have a privacy policy that you would have agreed to when you signed up to the webinar. Zoom, yes, doesn't necessarily have a responsibility to you as an end user, but I would have agreed when we signed up to Zoom that something to the effect of, I will ensure that I have authority to collect personal information from my customers to the extent that it's shared in the infrastructure. So there is various risks with doing it that way, but that's how a lot of infrastructure or software vendors handle it. They, as you've kind of alluded to at the end of your question, somewhat put it on the customer. That doesn't necessarily mean the regulator will like that, and there are other procedures and policies you can put in place depending on your specific situation. But a solution like that is often what's kind of come up with to handle that sort of scenario. In the GDPR, they have a lot more detail around policies you put in place in these infrastructure scenarios. So to the extent that you operate in UK and Europe, there's some other documentation that you need to put in place quite specifically in the infrastructure scenario. Then finally, we've got a question. Can you delegate actions about data breach security to contractors? You can definitely delegate actions. It's very common to have contractors and insurers that you would call when a security incident occurs. But showing that you've taken reasonable steps isn't just, I have someone I can call. The regulators wouldn't consider that to be enough to show that you've been taking proactive steps to protect from data breaches. So you would want to make sure that either you've engaged someone to do, let's say, security monitoring in your business. Again, having an internal response plan, even if it just says in the response plan, step 1 is to contact our vendor, step 2 is to provide them with XYZ information. That level of detail internally, I think, is what you'd kind of want in place. And then another question is, the participant signing up to this webinar an agreement to your permission to store and use their personal information. So I'm not actually sure what our team put in the terms and conditions of our webinar sign up, but we probably would have had a link to our privacy policy and a collection notice, and that would have said something along the lines of, you agree to for us to use the information for the purpose of this webinar and to send you some information afterwards, in relation to the offers flowing from the webinar, etc. So we would have permission to use the information for those kinds of purposes. It doesn't mean we can necessarily go and sell it to third parties and so on. That would require probably more specific notification, but that's kind of how, again, the privacy policy and collection notice may work in the context of something like a webinar. So moving through to beyond the Privacy Act. So privacy doesn't just exist in the context of the Privacy Act. There are other specific laws, and this is where it can get a little complicated, at both a state level and federal level in Australia that also apply in relation to personal information. So complying with the Privacy Act is definitely the focus of what you want to be thinking about. But if you're in a specific industry, for example, if you work in childcare, there's a Child and Young Persons Care and Protection Act. This has specific laws about the way that you collect the information of minors and what you must do to handle that, and specific security measures you may need to put in place that may be a little different to what the Privacy Act requires you to do. So you may need to do both. If you work in the health industry or collect health information, there's state-based laws as well that sit on top of the Privacy Act. If you're doing email marketing, you do need consents if you're governed by the Privacy Act to send out certain forms of emails to people, but there's also the Spam Act which is a kind of separate act governed by a separate regulator, which also has some rules around, at least when you're sending out emails to individuals, making sure there's an unsubscribe function and that you have consent to do so. So there's similar kind of requirements around email address collection to be aware of. If you do direct marketing, there's the Do Not Call Register Act, where people can say, don't call me, and ban themselves from kind of receiving outbound calls. So if that's a strategy that you comply with, that's not in the Privacy Act, but still a piece of privacy related law you need to you comply with. If you want to survey your employees, watch what they're doing, there's some laws around that. And if you want to record phone conversations, many people would have heard this call is being recorded for quality and training purposes message. That's somewhat a privacy related law under a different act. So for specific things or actions that you're doing, there may be other laws that apply. So worth being aware of that. And again, if in doubt, just checking with a lawyer to let you know if there's other procedures you may need to follow. So we've talked a lot about part one, which is the kinds of documents you want to put in place and procedures you want to put in place in your everyday business operations. Key takeaway, hopefully for everyone here, is privacy policy, privacy collection notice, and if you can, think about some internal procedures. Make sure you've got the privacy clause in your service provider or supplier agreements. So that's stuff that you could do today or should think about doing today if you don't already have it in place. Now let's move into the notifiable data breaches. So what do you have to do if an incident occurs? Now, first of all, fingers crossed, no incident occurs to anybody here. But if it does, you want to make sure you're prepared, and you want to make sure you're ready to comply with the legal requirements. Now, again, currently the notifiable data breach scheme has the same application requirements as the Privacy Act. If you're under 3 million in revenue and you don't have these special types of information, you may actually be exempt from the data breach scheme, and you may not need to send out notifications to your customers in the same way that you would if you're above the limit. So definitely a threshold question you want to check if a breach occurs is, does this scheme actually apply to me? Even if it doesn't, the procedure is still a good one to follow. And as I said, it's very possible in the next year that that exemption gets removed anyway. The act that covers notifiable data breaches, there's a piece of law inside the Privacy Act that requires you to follow a 4-step procedure. Step 1 is, you find out there's a breach, contain it. And this is an operational question, but before you do anything, you need to take some steps to try and reduce the risk of ongoing damage to the business. So this may involve restoring from backup, shutting down servers, whatever it is that you can do. If you have any information about a data breach, fixing the problem, or starting to take steps to fix the problem that caused this breach in the first place. So that's step 1. Step 2, assess the damage. So you need to work out, and you'll need this for steps 3 and 4, but also because you're going to want to know for your business, who was affected, what actually happened to them. Was it all of your customers' information, or was it just a list of email addresses that got breached? And what is there a ransomware message or no message? Do we think it's high risk, medium risk, low risk? What is the current threat level, if you will, of the data breach? Again, going to help you to further contain the risks, and 2, it'll help you know exactly what damage has occurred. 3 is notify. So if the notifiable data breach scheme applies to you, and again, it will apply to many businesses, but there are these exemptions. But if it applies to you, you are required to make fairly fast notifications to the OAIC, or the Privacy Commissioner. So you got to tell the government regulator, we, X business have suffered a data breach. We've assessed it, attempted to contain it, and here are the details of what's occurred. And second of all, you need to notify your customers. Now, you don't always need to notify all affected customers. If you can find out that, let's say you got 100 customers and only 10 were affected, if you can really isolate that only those 10 were affected and have what's called a substantial risk of harm, you can just notify those 10. If you can't work out who was affected, there's steps that the Act suggests in terms of posting a message on your website or sending out more general notifications to all customers and so on. And a lot of larger organizations do send out general notifications just because they're not really ever sure very quickly as to what the extent of the breach is. But the Act does allow you to notify a subset of individuals along with notifying the regulator. And that notification, of course, the regulator may ask you some questions. If you can show you had a data breach response plan, you took the best steps to contain it, you assessed the damage quickly, you had these privacy policies and other documentation in place, when it's reviewed, you can show that you've been operating a well-run organization in accordance with the Privacy Act. The risk of you getting fined will be significantly lower than the inverse, where you've taken no steps to put privacy procedures and manuals in place. A breach has occurred. You've been slow to contain and assess it. This is where you can really get fined. And not only can you get fined, you could potentially have liability to your customers for negligence as well. So these are more reasons when a data breach occurs to have made sure that, as per my previous section, you had the documentation and procedures in place. The final step that the Act mentions is a review step. What you want to be doing, and particularly if you have ongoing communications with the regulator, is showing that you're reviewing your procedures, you're putting in new measures in place to stop this data breach happening again. And so that's the kind of final step of the notifiable data breach process. So hopefully that gives people a bit of a sense of what to do if there's a data breach. Of course, we'd always recommend, if it occurs, getting on a call with our team or a lawyer of some description, and getting some advice on exactly what you need to do if a data breach occurs, because you do need to move relatively quickly, both operationally, but also for some of these kind of legal steps. And again, that's why a response plan, having one in place, can be really helpful, because you can just follow the procedure straight away. Now, just moving on to another topic, access requests and complaints. I mentioned earlier this requirement under the Privacy Act to deal with requests that you may get from customers, or complaints you may get from your customers about how you're using their personal information. It's required under the Privacy Act that a business has a way for customers to contact them and make complaints or request information about how people's personal information is being used. And so we recommend pretty much all businesses have some point of contact, or maybe an email address. I think for us, we may have something like privacy@sprintlaw.com.au, where on our privacy policy and on your privacy policy, it's very clear that customers can go to that address and ask any question about their personal information. Now, generally, you want to comply with the request for how you're holding and using their personal information to the extent that you can. If there's a good reason that you don't want to comply with it, maybe you can't share it because it reveals some commercially sensitive information, or maybe you can't share it because there's some other legal reason under some other law. There are circumstances where you can refuse access requests, but you need to have a process for it. And complaints can be made by customers, again, to the regulator, who, if you don't have a good procedure in place, you can be fined for them. So it's a good idea to have at least an email address set up and some procedure in place for responding to requests and complaints about how you're holding personal information. And yeah, I just touched on this one, which is you can refuse it, but there has to be certain justifications, and you've got to give them a notice explaining why you've refused it. So moving beyond legal protections, which is somewhat beyond the scope of this webinar, I would encourage people to take steps other than putting legal documents in place to protect your business from privacy or data-related incidents. Most businesses should consider getting cyber insurance, given the frequency of these attacks and potential liability. Insurance policies can help pay for a lot of the costs associated with a cyber incident, and potentially legal advice and fees associated with managing a data breach. Think about regular security reviews to your systems. Get experts to look at your how you have things set up. Think about reviewing where in your business personal information sits. PII, personally identifiable information, the same kind of term we've been using. I mentioned earlier, we do this regularly. We look at where in our systems do we store all of our customers' personal information, and how can we make it more robust and protect it against risk by potentially reducing points of failure. So think about doing that regularly, and potentially setting up a a table that shows, for example, the systems where personal information is and steps that you've put in place to safeguard it. Train your staff on security, cybersecurity, how to identify phishing scams and these sorts of things, and set up some of these internal policies. If you're doing all this stuff, you have your legal documentation in place, you have cyber insurance, you're doing regular reviews, you're training your staff. Even if there is an incident, which hopefully there wouldn't be because you've taken so many steps, you'll be fairly well protected from potential legal liability and hopefully fairly well covered by insurers. So you can navigate the storm without it necessarily being business ending. But if you haven't put these procedures and protections in place, you could be significantly fined, significantly liable, and really be not ready if something goes wrong. So definitely worth thinking about your cyber strategy more broadly. So I'll just finish up by touching on these law changes I've been foreshadowing a little bit. Last year, the law changed in the Privacy Act to increase the penalties for interferences with privacy, to expand the reach of the Privacy Act, and to give the privacy regulator more powers. What does this mean? It means you can be fined a lot more, actually up to 50 million for businesses. They probably wouldn't issue fines of that size for small businesses unless they did something really, really bad or had repeated offenses. But you can see there's not really a reasonable cap on what the fines could be. It's much more than a parking ticket, and they really are trying to make examples of businesses that are not complying or being negligent in relation to privacy. So this is why it's becoming more important. And there's more power that the Privacy Commissioner has, including interagency sharing, which means they can learn more about your business from other regulators and use it to identify people that maybe have been subject to spam complaints about their email policy that could put a red flag to the Privacy Commissioner. So this all happened last year. It's being rolled out at the moment at the OAIC, and we expect there to be more penalties and more fines happening over the next couple of years from the privacy regulator. And as I mentioned, this big change, it's not confirmed, but the federal government has proposed potential reforms to the Privacy Act, including a big one for small businesses, which this 3 million threshold I've mentioned a few times in this presentation is being talked about being removed, which would mean that, it's not optional anymore. And it's not just recommended, it's in fact mandatory for small businesses to comply with the Privacy Act. So worth being aware and keeping an eye out for that law change, which is expected to be legislated sometime next year. So that brings me to the end of the content for today. Thanks so much, everyone. I hope you found this useful. We're going to continue to do quite regular webinars like these on various topics. If there's topics you'd love to learn more about, please do let our team know. And if you have any feedback on this session and how it could be better, would love to hear from you all. Thanks so much for your time, and we'll see you later.